Hi, everyone, and welcome to Elderly Exploitation, what every Florida practitioner should know. Happy you're here. I'm looking forward to today's presentation, mainly because I've designed it and targeted it toward my fellow practitioners and those that don't necessarily practice in any kind of elderly exploitation, family law, or elderly law type practice. It's actually it's designed to kind of explore the ways elderly exploitation comes up in areas of law that you may not anticipate, or maybe 15, 20 years ago wasn't really on the radar. And so for that reason, I'm excited to kind of bring what I do every day to my fellow practitioners who maybe don't do this every day, and give them some food for thought. All right, let's look at our agenda today. The introduction here is just what I went through, and we've organized it by areas of law that I sort of want to go by after our introduction of what elderly exploitation is. We're going to look at how elderly exploitation applies in family law matters. Divorce, dependent care are two main areas in family law that I see this coming up more and more each day. Elderly law and exploitation as it applies in business law practice. I again practice with a lot of business law attorneys here at my firm, and know a lot in the local community. And it doesn't surprise me anymore, but it did at first, how often these kind of issues are coming up and creeping into their practice as well. So we'll look at some key things there that you may want to know. The fourth section is elderly exploitation by fiduciaries. Depending on many practices of law, you may have fiduciaries as clients, people such as professional trustees, guardians, CPAs are as fiduciaries, managers, finance managers, things like that. And then at the end of the day, we as attorneys, aren't we fiduciaries as well? At least in some sense of the word. And then finally, we'll conclude by looking back at what we just learned and seeing how elderly law, and especially elderly exploitation, is not just limited to one area of law anymore. So our introduction is just simply, let's go back to basic. What is elderly exploitation? Under Florida Statute 825.103, subsection 1, you'll see it's defined as financial exploitation is knowingly obtaining, using, or attempting to use an elderly person's funds, assets, or property with the intent to temporarily or permanently deprive them of its use. And then it goes on to define an elderly person as anyone age 60 or older. We're just going to focus on elderly financial exploitation for purposes of this webinar, but be aware that that statute and the relevant statutes go into elderly exploitation, physical abuse, intimidation, harassment, things like that as well. And it also expands to cover vulnerable adults, which includes elderly persons, but also disabled and people that would be vulnerable to exploitation as defined in the statute. Again, today we're going to focus on elderly, but just be aware that there's the exploitation type realm that we're talking about is a little bit more broader than that, and certainly even broader than just financial exploitation. There's a civil protective definition as well that expands on this and kind of leads into what I was just saying. 415.102 subsection 8 of Florida statutes expands this definition to cover vulnerable adults, and also specifically says when a person stands in a position of trust and confidence or has a business relationship with the victim, that can be under the definition of what we're looking at in exploitation. Okay, let's look at some statistics and trends for elderly exploitation. If you've been practicing for more than, let's say, 20 years, as have I, you've certainly probably observed an uptick in elderly exploitation. I barely heard of it when I first started practicing a little over 25 years ago. And now it's my primary area of practice. So let's look at some statistics and trends that I found out looking at some online resources. According to the FBI Internet Crime Complaint Center, Elder Fraud Report, total losses reported by older adults topped $3.4 3.4 billion annually, with the average victim losing upwards of 35,000. Now, Florida is the fraud epicenter. I think we've discussed this in other webinars. It's pretty obvious why we have a pretty significant elderly retirement community. Another state that is dealing with this problem in a disproportionate manner is Arizona, for the exact same reason. A lot of retirees there. But Florida ranks second in the nation for elder fraud complaints, according to the FTC, with older Americans losing billions annually. 1/5 of Florida's entire population is over age 65. And so, more than 1/5 of Florida's entire population is covered under the definition of elderly. And that's not even counting into other vulnerable adults that may not be at the age yet, but still would fall into the exploitation protected kind of status. The iceberg trend, as they call it. Studies funded by the National Institute of Justice indicate that only 1 in 24 cases of elder financial abuse is ever officially reported to authorities. And quite frankly, I'm surprised it's even that high. Why? And that's the next question. Well, you can probably guess. There's some shame. There's some embarrassment for older people when they've been so-called snookered or taken. And then there's just the fact of their cognitive decline. They may not fully understand that they've been taken advantage of. If you deal with elderly people or vulnerable adults in any great detail, there's a spectrum of understanding, and there's certainly moments of confusion where the next moment maybe not. So someone can remember something or do something and then forget maybe at a different time. So they may not even realize they've been abused just because of their cognitive decline. Fear is a big one, especially when you're dealing with family or caretakers. Elderly people, any vulnerable adult who has caretakers and relies upon those caretakers, who can be family as well. It's a human nature. There's psychological reports has been done on this. It's human nature, especially as you get older. It's like almost like a child. You're dependent on that person, and you don't want anything to interfere with that relationship or cause you uncertainty. So they'll just ignore exploitation just to keep the peace, so to speak. So, like I said, I'm surprised it's 1 in 25 cases of elder financial abuse is actually reported. When you take all those factors into account. What's the law that we're dealing with today? Well, we have a few chapters that come into play. And you have to remember, financial exploitation is both criminal and civil liability is involved. The criminal aspect is pretty serious. It's our statute 825 serves as a national benchmark for criminalizing actions against seniors, and it's been toughened up over the years. Our criminal penalties are outlined in they're tiered, and they're all felonies depending on the amount of money that's involved. And I've outlined them there. You go from 50,000 or more as a first degree felony to 10,000 below being a third degree felony. Also, 825.1035, even though it's a criminal statute, sometimes people overlook there's a civil provision in there for injunctions. 825.1035 has an immediate civil remedy, enabling victims or their advocates to file for an injunction for protection against exploitation. It could be from freezing bank accounts, restraining the perpetrators from coming around, intimidating, and all this can be done prior to a criminal indictment. This is important because if you find out, let's say a caretaker has taken some money, from your father or your grandfather, and you report it, that's got its own process that you don't control. It may not even be ultimately, a person may not even be indicted or criminally charged, depending on your local state's attorney's office and how they feel about the facts. But that doesn't mean they're not a victim, and it doesn't mean that you don't want to immediately go into protective mode to the extent that the person needs it. And it's important to remember this. And it's also a good statute because it confirms that not just the victim has to apply. If only the victim could apply for the protective order, you probably wouldn't get many applications, because for all those reasons we just stated before, oftentimes they don't realize they've been a victim, or they don't want to admit publicly they've been a victim. So it outlines the advocates that in the statute that can make that application on their behalf. Also, some evidentiary issues that are always just good to know when you're thinking about if you have one of these situations, if you know what kind of and you're thinking about civil remedies, what kind of evidentiary issues and stuff. There's a 2-year non-relative presumption, and I've defined it there. It's found in section 825.103, subsection 2 of the Florida statutes. And what it says is when you're dealing with a person 65 or older, and non-relative has received $10,000 or more, or I'm sorry, more than 10,000 from and has been paid by that 65-year or older person to that non-relative, and they've known each other for fewer than 2 years, there's going to be a presumption that that's exploitation. And that comes into play a lot with your caregivers, with people who stop by to try to sell them something, and all of a sudden they gave them a gift of something valuable. And this can be extremely helpful with a presumption, because oftentimes there's no direct witnesses to the exploitation. Someone wasn't there when someone essentially convinced them to write them a check for something or give them this expensive item as a gift. So these presumptions can really help you in making a civil case, especially. And then again, 825.1035, don't forget the civil injunction power. These can be ex parte, if you can, meet the burden of proof of, imminent harm and things like that. You can use this tool to freeze bank accounts, stop, a check before it comes through, stop a sale if they've convinced someone to sign a deed, or a lien, or things like that, because they've got them to sign this contract that's been been procured by exploitation. And a big one, if you have, if you can stop assets from being moved outside the jurisdiction before you have time to pursue it criminally or file a civil suit. All those things can be very helpful. And in my just personal experience, courts are much more receptive to hearing ex parte injunctions when you can make out a clear presumptive case of exploitation, recognizing that elderly folks, if they lose their assets, lose their monies, a judgment's not going to do them very much good in their lifetime. So being proactive is sometimes the only way to protect them. I want to touch on this too as part of the introduction, because I get asked this about a lot. What is my obligation? Do I have to report something that I've seen that looks a little untoward? Under Florida law, there are mandatory reporters. Chapter 415 sets forth mandatory reporters and by description, and we're looking at section 415.1034 here. And it's any person must report, but they give you very specific categories: doctors, nurses, social workers, financial institution employees, and they get in there. We've put the number on there that where you can report if you happen to see it. 1-800-96-ABUSE. And they say failure to report is a first degree misdemeanor, and I think I'm still trying to find the person who calls and tells me they've seen prosecution on this, but there's no statutory remedy for failure to report. There's no civil remedy, at least not explicitly. And there is some case law that I've discussed in other webinars. It seemed to be the courts are maybe recognizing that there could be a civil remedy, but for the most part now, the most the courts note there is no statutory remedy. So that if you're going to have a remedy, it has to come under some other theory of recovery. And then I'm going to ask the question here, and are attorneys mandatory reporters? We're not listed in that section, but ethically, perhaps we are. We have an attorney-client privilege with our clients. So when we're dealing with clients, we have that overriding principle that we have to remember. We have to protect confidential communications. And so then we can see when perhaps our client does not appear to be with all their faculties, and maybe we observe in our in the course of our representation that they may be exploited by someone. They may be coming to us to essentially to help with the exploitation. They want to give this person a gift. They want us to prepare a deed. And if they're exhibiting, incapacity, confusion, and it looks like they're being actively abused or exploited by a third party, what do we do in those cases? And it's not in the attorney answer is just, there's not a clear cut answer because you have to weigh both of those principles. Now, we do have some rules. If you look at the Florida Rules of Professional Conduct, in the citation I put there, it does explicitly permit a lawyer to take protective action, including seeking the appointment of a guardian, if the client cannot act in their own interest. But you can tell by the definition, protective action. Well, what's protective action? Cannot act in their own interest. It still doesn't give us specific guidelines. It's still going to be a case by case basis. You see there, I say attached a helpful checklist of issues to consider if you're representing a vulnerable adults, or someone that you think might be being exploited. I'm going to go over that list toward the end if we have time. I'm not sure we'll have time, but if not, you can certainly it's part of the materials, and I can send it to you if you like. But it's basically just a gathering of notes that I've made, that I've found other practitioners made, recommendations from professional organizations such as the bar and things like that. And hopefully that's helpful. But I think anytime you have a client that is coming to you and they want you to do work, and you suspect or observe things that make you suspect that this may not be of their complete free will, may be subject to exploitation, I absolutely urge you to contact the Florida Bar and try to walk that fine line in both protecting your client's confidentiality, but also protecting them. So, and then of course, it's even a more complicated issue when we're dealing with third parties who we may observe seem to be being exploited too, not people that we necessarily owe a duty to as they're not our client, but certainly calls into question how we handle ourselves with them, which could be a whole webinar on its own, but I just bring that up for my fellow practitioners to think about as we go through these issues. What you don't want to do is be held as you were working in tangent to exploit someone or assisting someone to exploit someone. And so that's what you need to keep in mind if you find yourself in one of these admittedly, sticky situations. So with that, with getting our background, our terms we're using, the kind of structure of the law that we're coming into this with, let's look at elderly exploitation and how it may come up in family law matters. The first, what's the quintessential family law matter? A divorce. When could this come up? When you have intervention of third parties in the divorce, I think it's probably one of the most recent ones I've seen. It's a growing trend in Florida. It involves, adult children or new paramours, a new girlfriend, boyfriend, wanting to urge a divorce, a dissolution. And the reason for doing that is because if the marriage is dissolved either through equitable distribution in a divorce, through a prenuptial agreement or arrangement, things like that, that third party can now maybe take forcible control over the person's assets, and because it's no longer tied to their spouse. And I have to say, I've seen this in real life examples more than once. There's a new term I always like to bring up, the new terms I see in elderly law, the new dictionary terms. Gray divorce. That's the new term I recently was introduced to. And in this case, we're talking about divorce among couples who are older, at least 50, I think is their general rule of thumb. And that statistic, as you see here, has doubled since the 1990s. In these matters, exploitation frequently surfaces when a new spouse or an estranged adult child manipulates the cognitively impaired person into a divorce to force the division and liquidation of marital assets. And sometimes that can run afoul of our capacity protections. You have to have capacity to file for divorce, just like you have to have capacity to marry. So you can have someone, trying to divorce one parent, but if the child is driving it and the girlfriend is driving it, it's not really the desires and the voluntary actions of the vulnerable person, the elderly person, that can be a defense to the divorce. And again, you see this in a lot of times when children, there's a happily married, maybe a second marriage, and they're happily, living their later years, and an adult child who, is concerned about money being spent by that marital couple wants to come in and force a divorce and force a breakup of the assets, and maybe a premarital agreement comes into play. So instead of now sharing their, their lifestyle together, now the one spouse is going to be kicked out. But their original the other spouse really didn't. There wasn't anything wrong with the marriage. It's just someone has inserted themselves, taken over, and here, sign these forms. Now, obviously, family law attorneys have to be aware of this and aware of their clients, what's motivating their divorce, and if it's really their their wishes and not the wishes of a third party being imposed on them. And I suspect everyone can do that, that practices in this area. But I think we got to think of the attorney on the other side and think about being proactive and raising that as a defense, or taking some kind of civil action to have the other person to really test out their capacity and whether they can even should be filing for this divorce. And again, even if we're just dealing with equitable distribution, which is the typical law in divorce in Florida, again, if you can wrestle joint assets away, at least have half of them, and the spouse that's estranged, now the person that's exerting that control has control of those assets, where before maybe if it was jointly they couldn't get to them. And again, these are examples that I've seen in real life. I've seen adult children um, assert themselves, and especially when one spouse is really, really sickly, and just take them away, and because they have a power of attorney or something, or they're the healthcare surrogate, and take them away. Next thing you know, the other spouse is getting divorce papers. I've seen examples where one spouse who's younger than the other spouse exploits the incapacities before filing for divorce by, for example, getting them to sign very good things over to them, making marital assets non-marital assets, maybe having them revoke a prenup, and then after they have everything they want, then filing for the divorce. So again, as practitioners, be aware of all these issues that could be going on, and see if any of them play into how you should be pursuing your family law matters. Other than divorce, I think another major area of family law is dependent care. There's there's the law that says you have to take care of your dependents, and that usually falls under the family law matter. And what this comes up in context of caregivers or family members who have essentially asserted themselves in the role of caregivers, and they're holding themselves out to be responsible for the care of their elderly parent or their elderly, ward. But they intentionally or through negligence failed to use that elderly person's income and assets for the necessities required for their core support and maintenance. And I see this a lot in the context of caregivers, where they come in and honestly say, I did a good job. They wanted me to have this. They told me they wanted me to have this bank account or this savings. And I don't think they're lying, but I think they fail to recognize that, if this person just gave you their life savings, and you use it, and you just took it, you recognize that that's for it's required for their support and maintenance, that's for their later years, and you're violating the law when you do that. And as far as family members, you can come into play. It may be a dependent care matter if you're using funds and as essentially as the next of kin, or the person that's in charge, and you're using their income and assets for your own items and not the necessities. And so sometimes that can be a family law matter as well. There's a family caregiver trap, and CPAs mention this to me all the time when it comes, tax prep time, they just get a bunch of bank statements and there's these large, undocumented numbers go into the kids or caregiver, and it's just put caregiver fees. And there's no arm's length personal care agreement, things like that. Now, arm's length personal care agreements are a real thing. Many practitioners, are very adept at preparing these. They come in handy, especially when you're dealing with applying for state aid and welfare benefits, things like that, or social benefits. You can pay caregivers, but it's got to be an actual agreement. It's got to be fair and reasonable in its terms and things like that. If you want to pay your family or you want to give them things and sort of as a thank you, sometimes just a thank you is for caring for me or to compensate them for caring for me, to define what is just a daughter being good to their father and what is, a caregiver kind of action. I highly recommend these get recommended, and I guarantee your CPAs will be glad that you have them. It makes it much easier come tax time for them to properly code and report these kind of things. Just some statistics here. MetLife Mature Market Institute data reveals that nearly 60% of elder financial exploitation perpetrators are family members, many of whom act under the guise of providing dependent care. I'm shocked it's only 60%. And yes, it's countless how many cases I have of, usually it's one child who was, or maybe the other children who didn't live there thought they were taken care of. Mom and dad were grateful. They moved in, they seemed to be taking care of them. And then, mom or dad dies and they realize there's no money left because they've been siphoning it off. Having mom and dad invest in their companies, things like that. And they say, that's okay. I took care of them for the last year, so I've earned that money. Yeah, that's probably you're gonna find yourself in the exploitation area and definition unless they've got real value for money and there. And so just be aware that family members are not immune from hurting their own family. And as I've cautioned people before, it's not even always a family member who's a bad person. There's always a rationalization, a justification for people when they get into a certain situation. They may not come across as they certainly may not come across as what you would say is an abuser. They may come across as nice and caring, and they may in fact care about the person, but they can't stop themselves from exploiting financially for whatever reason. All right, now we're into section 3, elderly law. Elderly law and that includes exploitation that comes up in business law practice. And I made it a little broader here about the elderly law because there's some things that's even broader than exploitation that comes into play when you have a business law practice these days and when you're dealing with elderly people. Again, the definition is the default definition for an elderly person that comes under the statutes is 60. I mean, it certainly can be younger than that if you have other things that make you vulnerable, such as disabilities. And as we've seen a lot of these protective presumptions and stuff come into play at 65. This day and age, with medicine being what it is, I think we'd all agree it's not unusual to find 60, 65-year-olds actively working or being part of their business or business practice and things like that. So it's certainly in the business law arena, it's certainly reasonable to believe that you may cross paths with someone that may be subject to exploitation. And again, another reason to be aware of these things. What kind of laws are we thinking about when we're going through this analysis? Well, we got the Florida statute, the 607.0831. That deals with corporate director liability. If you got an older person being a director who has liability, or conversely is being a director is maybe exploiting an elderly person involved in the company, think about how the liability may come into play and affect the business as a whole. We also have Florida statutes 825.103 subsection 1 subset A, and that's where we talk about the business relationships. That chapter is full of the various different business relationship, LLCs, things like that. What I want to talk about in this, what I'm actually thinking about in this kind of analysis is what we call the closely held corporation. The one that only has a few shareholders, oftentimes family members, usually no more than 2 to 4. There's is not a marketable interest. It's just the people that started the company. It's intended to stay small, stay closely held, where it just stays with them or their family, things like that. And they're not just shareholders or members, they're actively involved in the management and the running of the company. So let's put this in some context. We have, you can have exploitation in corporate governance. It occurs when minority shareholders or family business partners squeeze out an aging founder who has dementia, or say for example. Florida's elderly exploitation laws explicitly cover individuals who share a business relationship. That if you remember back one of those definitions when we were talking about what is exploitation, there was fiduciaries or someone who shares a relationship as part of that definition. That was explicitly added at some point. It was done that to remove a previous, what probably someone would call a loophole, that allowed corporate maneuvering, that if you were doing it in a corporate context, you could escape criminal scrutiny or civil scrutiny. So as not being technically exploitation. So recognize now that having a business relationship person puts you square in the definition of what we're looking at for elderly exploitation. Another area it can come up in business law practice is in contracts. I mean, validity of a contract, but one of the first things is not just an intent to contract, but an ability to contract, having capacity. There's common law doctrines of undue influence, lack of capacity. We're probably all familiar with those, if not from nothing else from our law school days. But be aware, it comes up a lot, obviously, in estate planning kind of situations and wills and trusts and things. But the doctrines are the same. The estate of Carpenter is a great case. If you do probate or trust law, you probably, especially litigation, you're extremely aware of that case. If you do estate planning, you're doing it to avoid running afoul of what we call Carpenter factors. But the Florida Supreme Court in that case did a really good job of setting forth what they called indicia of fraud, where there's an indicia that suggests there's undue influence. And there are good rules of thumb to use just in any kind of transaction that you do. You don't want to look like people are overreaching in a transaction, especially when you're dealing with someone who is vulnerable. And then a lack of capacity, in theory, that's a very legal term. Lack of capacity, you have to be declared legally incapacitated to lose, to officially be lack capacity. But there's certainly degrees of mental infirmity that happens before you could get even to being declared legally incapacitated. But at the end of the day, every contract requires capacity. So keep those in mind when you're dealing in the realm of contracts and things like that. And Florida Statute 7325165. Again, that's these are principles we use in a lot of probate and estate planning and stuff, but they go across the board in any contracts. You look at the effects of what fraud, duress, mistake, and undue influence can have on someone's ability to enter into a contract. It has to be free of undue influence, duress, mistake. If they have someone pressuring them, someone that they're vulnerable to, that's pressuring them to sign this, someone who shows up at their door to sign up. I know they get a bad reputation, but like the solar contract people, the solar panel contract people, you show up one day, the person's in the middle of the afternoon, they're confused. You say, you come in their house, you say, you give them a lot of paperwork and they're intimidated and they sign. There's cases where people have alleged that and have been successful in that. All those things go into your business law practice. And when you're drafting contracts, when you're dealing with parties, keep these things in mind. And even to the extent of maybe warning your clients if they're in the consumer marketplace, that they need to be aware, especially in Florida, they're likely to encounter elderly and vulnerable adults and need to be aware of those extra protections that elderly exploitation has. In its simplest term, elderly exploitation says you're not acting arm's length with an elderly person in those situations that's contemplated by the statute. You have a duty to act above and beyond and with fair dealing. And so what better context does that come into play than with contracting? So if a business contract or asset transfer is executed when the perpetrator knew or should have known the elderly person lacked the capacity to consent, the contract is void ab initio. So that's the legal conclusion if you risk going into these contract or business relationships and you have reason to believe that the person lacked capacity to consent. Now, our fourth section that we said we would explore is elderly exploitation done by fiduciaries. And probably when I first started practicing as a lawyer, I may have thought that this was almost an oxymoron. By definition, aren't fiduciaries supposed to be looking out? Aren't they the ones that are supposed to be protecting and acting above board? But the reality is they don't always do that. And they're not, and so yes, their actions, if they don't do that, are their actions breach of trust, breach of fiduciary duty, all those things that we learned about in law school, those general principles? Yes, absolutely. But they've also committed elderly exploitation, which we know is also a crime and also a civil remedy. So let's look specifically at what the law says. The law on trustees. Well, Chapter 736 is our trust code, and 736.0801 of the Florida statutes, it talks about the duty to administer a trust fairly and to the benefit of the parties, the interested parties, i.e. the beneficiaries, Those things we're familiar with, but compare that to Florida statute 825.103, the elderly exploitation statute, and you see that if you breach that duty, you've also committed potentially the crime or the civil claim of elderly exploitation. Put it in context, a trustee commits exploitation if they breach their fiduciary duty to the elderly individual, but resulting in an unauthorized appropriation, sale, or transfer of trust properties for someone else's benefit. So there are breaches of trust that wouldn't fall into this definition. For example, if you don't account every year, that's technically a breach of trust, but it wouldn't be elderly exploitation because it doesn't result in a financial loss as contemplated by the statute. But some breaches, so not all breaches of trust are elderly exploitation, but some breaches are. Okay, powers of attorney. Attorneys, in fact, who act under a power of attorney is certainly the one I see the most as the most fraught with elderly exploitation. People who are supposed to be acting in a fiduciary capacity, the same as a trustee or guardian or other fiduciary would, but for some reason has not received that message. Many individuals, to this day, I still hear it. I had a power of attorney. I can do whatever I want. Not true. You're given powers, but those powers are constrained by the law, and you have to act in a fiduciary capacity and to the benefit of the person that's the grantor of the power. But this is the most common legal mechanism of abuse, and I confirmed that in the statistics, and just real life experience would have confirmed that to me too. So under Florida's permissive presumption of exploitation, remember where you're dealing with people. We looked at before where you're dealing with people you don't know, but here we have another presumption. If an agent under a POA uses the principal funds for a transaction that does not benefit the principal, the court presumes exploitation occurred unless the other agent can prove otherwise. So again, when a power of attorney, a person holding a power of attorney says, I gifted all this money to my grandchildren because I was given the power to gift. Well, you were given that power. It doesn't mean you can exercise it if it's in breach of your duty. And you may not be just, breaching your duty, but you may be committing a crime or opening yourself up to civil remedies for that. And, the civil remedies for exploitation, I know it's a little beyond this webinar, but they're much harsher than your normal damages. They include treble damages, attorney's fees, things like that. The last category guardian that I put on here is the guardians. Florida that's covered under Florida statute chapter 744. And then again, compare that to section 825.103, where it talks about a guardian or fiduciary if they do things that takes advantage of their ward or the person they're supposed to be in charge of that committed the act of elderly exploitation, if it results in a financial loss to that person. So if you're familiar with guardians, they can be professionals, they can be, private citizens, family members. In my experience, all guardians can do wrong by their wards. I mean, we've all read the papers. We know that. Just having a professional guardian doesn't mean it won't happen. But certainly individuals may be more likely, since they're not as familiar with the law and probably haven't served and they haven't served in such capacities before. But the court-appointed guardians are actually held to the highest legal standard of any fiduciary. They have a duty to account every year, to report to the judge, to be proactive in reporting to the judge on certain things. They're not allowed to take assets unless explicitly authorized by the court. And most of those in Florida, at least, many of them serve under what they call restricted depository, where they can't make withdrawals from accounts without court order and approval. But even with that, they have to track their distributions they make. They have to account for everything. They have to avoid self-dealing. It's not allowed by the rules. You can be held in contempt or face other sanctions under the guardianship code if you're a guardian, and you can be prosecuted criminally under Chapter 825 if it results in financial harm. So guardians are held to exactly like the other fiduciaries that we saw, even though you would think that with the court being so tight on them and so restricted on them that they wouldn't fall into this category very often. But like I said, we read the paper. Guardians do mess up sometimes. Elderly people in other wards suffer because of it. So the conclusion here, no matter what area of law you practice in Florida, the chances of encountering elderly exploitation issues are increasing every day. For a number of reasons, as we just went through, it's the population in Florida. It's the fact that elderly people live longer and are able to be active in business matters, active in the management of their own affairs longer to an older age than they used to be. There's a factor of families aren't the same structure as they were, say, 30 years ago. Elderly people are much more likely to be alone in the sense that they don't have family members nearby, maybe not even have a spouse, maybe living alone, and not have any kind of support group that comes from a family relationship, and are much more vulnerable to outsiders. The elderly exploitation statute, being so protective, being expanded to cover so many areas, is coming into play as we just went through in much more practice areas. And we all, including as attorneys, we all have to think about it and make sure that we're not somehow being, assisting in an exploitative transaction and things like that. I think we do have a few minutes that we can go through this checklist. I'm going to rush through it a little bit, but this is just to kind of get you thinking. Everybody should have their own list. But first of all, I think an attorney who observes sudden cognitive decline in an active client must balance the duty of competence with the strict duty of confidentiality. And again, that was what we were talking about earlier. When you see a declining client, but they've given you instructions, they want you to do something, and you're not. Maybe they don't want you going around telling people that they're declining and things like that. How do you balance it legally and ethically? First of all, start making observations. Keep a record. It's when you're asked about this later on, you don't want to just say, well, it's just my observation. You want to be able to say, on so-and-so day, they couldn't remember who their children were. On this date, they suddenly couldn't tell me what they just came into the office for. Or, one day they asked me to do one thing, second day they asked me a different thing. They expressed confusion. They were angry for no reason. Anything that is helping you lead to that. Keep a journal, keep a note. We're lawyers. We're supposed to be good at that. You're not a doctor. You can't medicalize. What I've suggested before and asked my clients and asking like, help me help you. Have them go to a doctor, urge them to go to a doctor and get some kind of testing done and some kind of opinion. You're going to get pushback sometimes, but it certainly doesn't hurt to ask, and it certainly doesn't hurt to document that. Try to keep a normal attorney-client relationship as much as reasonably possible. Anytime you kind of pose these issues or address these with your client, it's extremely likely they're going to be defensive, and it has a chance of ruining the trust, which is a quintessential part of the attorney-client relationship. So that's going to have to be something you try to balance as best you can. Try to be gentle. This is kind of a people person kind of skill set. Be as gentle as you can. Remember, coming from their perspective, they already feel vulnerable. They already feel like they're losing control of situations, and try to think of it from that perspective, and try to lead them to confronting their own vulnerabilities without the anger and the defensiveness, if possible. It's a tough tough to navigate, and I know that from personal experience. Assess understanding. Evaluate if the client can still understand the nature, purpose, and consequences of the legal decisions required in the engagement. I think you have to do this often if you're dealing with someone you suspect has diminished abilities. You have to reiterate for your own ethical duty, and to confirm to yourself that they actually understand what they're doing, the nature of what they're doing, the purpose. And if they forget or they can't articulate that to you, there's nothing wrong with telling them that you may not be able to help them, because as you're ethically obligated to be assured that they do understand everything before you help them in any kind of legal work. Determine volunteer support. Ask the client if they wish to involve a trusted family member or advisor to assist them, ensuring how you explain that that might affect attorney-client privilege. I have tried, before people get elderly, to make notes if they want me to if I ever have reasons of concern, can I contact your spouse, your children, things like that. And but again, you have to explain it to them when they have capacity and understanding, and I understand that they're essentially waiving attorney-client privilege for you to contact these people, at least maybe to a certain extent, that you have to reveal something confidential. This is more of protective action and trying to keep the boundaries of confidentiality in place. These are some things to think about. Evaluate the risk of harm. Is it, obviously if the risk is not much, that takes into effect how responsive you are. If we're just, but if the risk is substantial, either physically, financially, you have to take more action, or be inclined to take more action or protective action, I think. For example, if someone wants to come in and they want to give a small little gift to someone, a new paramour or something, you may have concerns, but in the big scheme of things, if it's not very much, they don't seem to be any immediate risk beyond that. Maybe it's less of a balancing there. But if they're getting ready to transfer their bulk of their financial, or you see signs of physical abuse, then that obviously weighs in favor of taking more protective action more quickly. We have that doctrine of implied authorization to reveal information about our client when it's necessary to protect the client's interest. Obviously all of us, we don't want to be put in a position where we have to be the full, make the full judgment call on what's reasonably necessary to protect our client's interests. We all seek to reveal information after we've gotten permission from our client. But remember, that is there is some implied authorization that you can use as you make your decision on what to reveal and what to do to be protective. And there's nothing wrong with asking, again, for professionals, whether it's from other elder law attorneys and experts, from medical dietitians, and you can do that you don't have to give details of your client. You can describe certain things. And again, the call to the Florida bar never hurts either. then finally, after you've done all these things, if you decide that you need to do something, you got to select the least intrusive remedy. I think that goes part of that what's reasonably necessary kind of standard. You know, is there the first thing, utilize existing structures? Are there power of attorneys or other designations in place that can help? Are there people, set forth in those documents that you're already authorized to maybe set contact because you had to send them the durable power of attorney, and see if that if you can talk your client and saying there's you got this durable power of attorney, why don't we start letting them get more involved in your affairs, for example. You can actively seek out surrogate decision makers, and to the extent that it's consistent, you can share certain information with them and retain the privilege. You just have to do the analysis there. Is it reasonably necessary to discuss those things because there's a joint interest there. Consider your guardian ad litem or using the guardianship statute. If you have to, I would say this is a more severe remedy. Even a guardian ad litem, it involves the court appointment, and a guardianship is an extremely formal process that takes away rights of your client. These are certainly the more intrusive remedies, and but they're there if they're needed. And there are definitely cases where if you're seeing someone being abused, being isolated from family, and then sometimes that's all you can do. Okay, and then management, the engagement of the withdrawal. May come a point where you have to withdraw. If you've been doing all this, you've been having good communications, taking good documentation, but you may have to tell them at some point, I can't have this will. I can't help you execute a will or other contracts because I just don't believe you have the legal capacity or that you're acting of your own free will. And you want to document that, and you want to explain to them their options, and that they're certainly permitted to go to other attorneys who may feel differently, but that's in line with your ethical obligations. That's what you've decided you have to do. If you can't if you can't represent them effectively, then you have to withdraw. That's from representation. That's the rule. Make sure in withdrawing you do protect confidential information and don't prejudice your client any more than you have to. If you're withdrawing as a matter of record, you certainly want to use the general terms, irreconcilable differences, professional considerations require withdrawal, that kind of thing. So I'm glad we had time to go through that, since this was tailored toward practitioners. Again, thank you for joining us today. I hope that this was helpful. I hope it starts a conversation. As always, I welcome comments and questions. My contact information there is there on the screen, and feel free to reach out to me if I can be of assistance or if you'd like to share an anecdote
So
with me.
we have a couple questions, Teresa. So let me just go through real quick. Okay, so I work at a homeless shelter. Do you have any tips for dealing with elderly individuals who are being taken advantage of regularly, experiencing homelessness, or how to address it?
Wow, that's a pretty dynamic avenue because you have homeless people who are also elderly. I don't know how much they can be financially exploited, but I'm guessing they're subject to abuse in addition to the financial. Um, Reporting, if you suspect a crime, report it. There are mechanisms for filing in the guardianship statute. There's if you think it's to the point where they lack capacity and need a guardian, there is for the indigent, there are methods to go through if you look under the statute.
So one other question here. What are some other telltale signs that they're being exploited? And if I suspect an individual being exploited, how do I address it or report it?
Okay. Well, I gave you the number for the abuse hotline. The Florida Department of Elder Affairs is a great resource for reporting. Adult Protective Services the branch is actually tasked with that. Your local police department is a good source. As far as telltale signs, again, withdrawal, not all of a sudden not wanting to talk about there are things that an individual keeping them isolated. And all of a sudden not having money, all of a sudden they can't pay their bills, all of a sudden they don't, or you ask them what's going on, you don't have food here, and they just keep saying this one individual's name over and over that's taking care of them. Those are all hallmarks that there's exploitation. But and unfortunately I have seen that. I've seen it where it got to the point where they've been exploited so much their bills aren't even being paid anymore. So all those are things to look for. And again, I urge you to report to any agency that handles this. Again, it could be Adult Protective Services, that's the state of Florida. It could be your local police department. And then there's the abuse hotline that I think I mentioned earlier in the webinar.